Today was an extremely unproductive day where you get ready, you go to court, and at the gate itself, you are told that the opposing counsel is not available, because of which the matter will definitely get adjourned. So I thought I'll make at least a little bit of productive use of the day by talking about this one thing which has been on my mind for quite a while. I would like to call it the tale of two bails: how to protect innocent falsely accused of rape from jail. So the first story is of this family who came to me approximately a year ago. They said that the boy has been, the child, their son, has been falsely accused of rape. And I don't want to go into the allegations much, because what we want to talk about is how we secured the liberty of this person. So the person was still in the US when the FIR was registered. The police issued summons to join investigation. He replied to each and every question, he gave his version of events, everything, but through email and through phone calls. But of course the police say, we need you here to join investigation, which of course means that we want to arrest you on the basis of completely on the face of it false allegations, and then we'll see what has to be done. In the meanwhile, the family was ill advised to not even move an anticipatory bail application. Now, what had transpired was, while the family was sitting in front of me, they receive a summons from the magistrate court, because what had transpired was that the investigating officer in the matter, he compiled a charge sheet based out of all the evidence that he had collected, and at the end he mentioned that apart from all of this, there is also the aspect of taking the accused person into custody, interrogating him. And so once we are able to trace him down and we take him into custody and we interrogate him, then we will file a supplementary charge sheet before the court as well. But on the basis of this charge sheet, summons were also issued out to the accused person in this matter. Now, there were two challenges before us. One is, if the accused person in a situation like this appears before the magistrate, even the magistrate immediately would say, we need to take you into custody. And the second bigger, on the face of it, challenge is that right now the boy is in the US, and so how does he come down to India and not be arrested, because there is a lookout circular which is open against him. So the moment he arrives in India, on the basis of the lookout circular, he will be detained by immigration. The investigating officer in this matter will be called, and he will fly down to wherever this person is, or drive down, and he will take that person into custody. Now, there is another provision of law that even before the magistrate court, or whichever court you are being, the case is going on, you can surrender and you can move your regular bail application. And another aspect is that when a regular bail application is being argued, it has different parameters compared to a anticipatory bail application. Now here we tried to use a technicality in law where we said that because of virtual hearings being allowed, the accused person is joining via video conferencing these proceedings before the magistrate court. And we said we are moving a regular bail application before this court. The magistrate says that I am not going to decide this regular bail application, especially when you have never joined investigation and you have never you're not even before me. And the magistrate says, leave it be, I will just commit the matter to the sessions court. Now, before the sessions court, immediately we again move an anticipatory bail application. And the sessions court says, what is the hurry? When we point out that the charge sheet has been filed. So the sessions court says, okay, if the police did not want to arrest, then might as well, wait for the charge sheet to come to me. So we did this, I think 1 or 2 days before the charge sheet was filed. So we got the bail application before the sessions court also disposed of. When the charge sheet was subsequently filed before the sessions court, at this stage the sessions court was, had the memory of us having moved a bail application, which the judge said on this technical ground you don't need to move this bail. And when we appeared before the judge via video call, the accused appeared, and of course the counsel appeared physically, and we agitated this point that the charge sheet has been filed, it has been committed to the sessions court, then what is the purpose of me being taken into custody? So the court may grant me bail. And so, without even applying for anticipatory bail, without moving a regular bail application citing all the facts and circumstances, we just moved a one-page bail application saying that we are here pursuant to summons by the court, and that is why please give us bail. And the court did indeed give us bail. But what is interesting is something that I should point out in this situation here as well, is although we kind of got off on a technicality, subsequently, because of the lookout circular, when the client did travel to India along with a certified copy of the order of the court, yet the immigration people still kept the accused client in detention, informed the investigating officer. Investigating officer came down to the airport, and in the garb of stating that I need him to join investigation, the investigating officer still kept the accused person in his detention for almost about 20 hours or so, interrogated him thoroughly, which we had no problem with. But the fact is that you go and nab this person this illegal way despite having secured bail from the court, and this is settled law that if the person is released on custody, if you do not have the power to take him into custody, you cannot have a lookout circular also pending against the person. And so we moved an application before the Sessions Court, now the trial court in the matter, for strict action against the investigating officer for doing this act of detaining my client for almost 20 hours and then letting him go. In response, the investigating officer, because we moved this, moves a cancellation of bail, saying that no, we still want custodial interrogation of the accused person and he's not cooperating with investigation. And we of course oppose that, and the matter gets dragged on for several months. Interestingly, the investigating officer himself, about 3 days after moving this cancellation of bail application, passes away with a heart attack. And then the matter is pursued by the state, and the other functionaries, another investigating officer is appointed. Now, around the same time that we got bail for this client and this cancellation was moved a week thereafter, another interesting situation transpired. What happened here was that this other client was facing again rape charges, again false promise to marry rape charges, as was the case in the first case. And here the police said that we can clearly see that no offense is made out. And so the police, what they did was they filed a charge sheet without arrest. Now here again we move the session, the charge sheet is filed before the magistrate court, and again our difficulty is that there are various judgments, court on its own motion versus CBI, and there was a recent judgment of the Supreme Court on this issue as well. There is still no complete clarity on if after filing of charge sheet, especially, so now we know for certain that cases like cheating, extortion, any sort of physical assault, these kind of cases, there will be no issue if you appear before the magistrate, especially if the charge sheet has been filed. But in a severe case like severe allegation like rape, it is still a little bit of a question mark. The magistrate can still commit you to custody. So we tried to pull off the same stunt. My lord, the accused person joins virtually and he submits himself to the jurisdiction of the court. Please admit me to bail and then commit the matter to the Sessions Court. Magistrate here says, I don't care. I am not going to dismiss. I'm not going to do anything. I'm just going to keep this matter pending. And the magistrate said that, if you do not apply for anticipatory bail, I am going to take him into custody. So we say, all right. Then we move the Sessions Court for anticipatory bail. And the Sessions Court also agreed with our proposition that if the police themselves have said that they do not want custody and that the charge sheet has been filed without arrest, the investigation has been completed, there is no reason for the magistrate to say that you must seek anticipatory bail, otherwise I'll take the person into custody. However, the Sessions Court also understood our constraints that, an order must be passed. So the Sessions Court was kind enough to immediately grant anticipatory bail, and taking that, we then appeared before the magistrate court. We then moved a formal one-page bail application. The Sessions Court has granted an anticipatory bail. We now submit ourselves to the jurisdiction of the court. Please grant me bail. The magistrate then gives us bail and then commits the matter to the Sessions Court, where we also ultimately were able to challenge the order of the Magistrate Court summoning us, and we got a stay on the trial as well before the Honorable High Court, pointing out that this is a completely false and frivolous case. It's a pretty long video, but what I wanted to highlight by these two occasions for lawyers and law students who watch me out there is that there is a lot of scope in criminal law in the procedure to get relief for your client, even if the client faces some very heinous allegations, and you should just keep trying every which way to get relief for your client, no matter what. And there are a lot of occasions you will find that one of the things that you kept trying, you succeeded, and that makes all the difference in the world.